This is EconWorks. In this episode, we examine the economic foundations of reverse payment antitrust law through the lens of the Takeda verdict.
Okay, let's unpack this. Imagine you have a locked safe, right? And the only way to find the combination is to, well, open the safe first.
Right, which is impossible.
Exactly. It's a completely impossible logic puzzle. But that is exactly what the United States legal system has asked juries to solve when they're evaluating these billion-dollar pharmaceutical disputes.
Yeah, and it's a puzzle that actually affects you, the listener, pretty directly.
Oh, absolutely. I mean, you interact with this exact puzzle every time you pick up a prescription at the pharmacy or, look at the health insurance deductions on your pay stub.
Because the invisible forces deciding those costs often come down to these really complicated closed-door legal settlements.
Right. So today for our deep dive, we are relying on a really detailed EconWorks article. It's titled The $885 Million Question, Actavis and the Circularity Problem.
And the mission here is to untangle how a well-intentioned Supreme Court rule accidentally created an unsolvable math problem.
A math problem that is literally deciding the future of the pharmaceutical industry. So to see how the legal system ended up functioning like a locked safe with the combination inside, we have to look at a historic verdict, right?
Yeah, we have to start with the verdict that forced this entire conversation into the spotlight. So on May 19th, 2026, a federal jury in Massachusetts came back with an $885 million verdict against Takeda Pharmaceutical.
Which is huge. But wait, it actually gets bigger, right?
Oh, yeah. Under federal antitrust law, damages in these kinds of cases automatically treble.
Treble, meaning they multiply by 3.
Exactly. So that brings the total penalty hanging over Takeda to roughly $2.5 billion.
$2.5 billion. I mean, a number that massive usually implies some kind of blatant, almost cartoonish level of corporate villainy.
Yeah.
But the reality is far more nuanced than that.
It really is. This penalty actually traces back to a 2014 settlement over a constipation drug called Amitiza.
Right, Amitiza. And this was a deal struck between Takeda, who owned the brand name drug, and 2 other companies, Sucampo and Par Pharmaceutical.
But before we can judge that specific settlement, we really need to understand why pharmaceutical companies are just constantly suing each other in the first place.
Yeah, because I think, a lot of people just assume a patent expires after 20 years, and then generic competitors just naturally appear on the shelves the very next day.
Right, like it's automatic.
Yeah.
But it's not. The process is incredibly combative. And it was actually designed to be that way by a law called the Hatch-Waxman Act.
Okay. Hatch-Waxman, how does that work?
Well, Congress wanted to encourage generic drug companies to challenge weak patents. The goal was so consumers could get cheaper drugs faster.
Which makes sense.
Right. But to incentivize these generic companies to spend millions of dollars on lawyers and research, Hatch-Waxman offers this massive prize.
What's the prize?
If you are the first generic company to file a challenge against a brand name drug's patent, you get 180 days of market exclusivity.
Oh, wow. So for 6 months, you are the only generic option on the shelf.
Exactly. You get to charge a premium and, well, you make an absolute fortune.
Okay, so Par Pharmaceutical filed that exact challenge, which is called an abbreviated new drug application, or an ANDA, to go after Takeda's Amitiza patents.
And Takeda did what brand name companies always do. They sued Par for patent infringement to protect their monopoly.
Right, but they never actually went to trial, did they?
No, they didn't. They settled. And the terms of that settlement are exactly what the recent Massachusetts jury had to evaluate.
So let's break down those terms. Par agreed to delay launching their generic Amitiza until January 1st, 2021.
Yes. And in exchange for that delay, Takeda gave Par a profit-sharing arrangement and an authorized generic supply.
Okay, an authorized generic supply. That phrase feels like the linchpin here. What exactly is an authorized generic, or an AG?
So an authorized generic is when the brand name manufacturer quietly produces its own generic version of the drug to compete with the challenger.
Oh, I see. So if Takeda launches an authorized generic during Par's 180-day exclusivity window,
then Par's golden ticket is suddenly totally worthless.
because they have to split the market.
Exactly. They split the market and prices crash immediately. So as part of this 2014 settlement, Takeda made a no AG commitment.
Meaning, Takeda promised not to launch their own generic at Chan to ruin Par's 6 months of exclusivity.
Right. And the plaintiffs in the antitrust lawsuit calculated the value of that promise, plus the profit sharing, at roughly $210 million.
Let me just make sure I have this straight. Takeda basically transferred $210 million in value to a competitor.
Correct.
And in return, that competitor agreed to just stay out of the market entirely until 2021.
Yeah, that is the literal definition of a reverse payment settlement.
Yeah.
The brand name company is essentially paying the challenger to go away.
I mean, on the surface, paying someone not to compete against you sounds like a textbook antitrust violation.
It does look bad.
Right, it looks like you're using your deep pockets to just buy a delay in competition, which keeps prices artificially high for everyday consumers.
But Takeda's defense argued this was completely conventional. They said it was just a legal settlement under the Hatch-Waxman framework.
Why would Takeda argue this was completely conventional? Isn't a $210 million payment an obvious red flag?
What's fascinating here is that Takeda's argument relies on...
value. Okay, explain that.
Well, they pointed out that allowing Par to enter the market in 2021 was actually an early entry. It was well before Takeda's patents were officially set to expire.
Oh, so in Takeda's view, consumers were actually benefiting from cheaper drugs years ahead of schedule.
Exactly. And furthermore, patent litigation is not just expensive, it's highly unpredictable.
I can imagine.
Even if you have an ironclad patent, juries can be unpredictable. Judges can make errors.
So Takeda is claiming the $210 million wasn't a bribe to delay competition.
Right. They're saying it was a rational, quantifiable reflection of the money they saved by avoiding litigation risk, just wrapped up into a legitimate commercial distribution deal.
Which brings us right to the core tension of this deep dive. We have a $210 million wealth transfer. Plaintiffs say it's an illegal payoff to keep insurance premiums and pharmacy prices high. But the defense says no. It's an efficient business deal that secured early access for patients while saving everyone millions in court fees.
And if the payment could logically be either of those things, the question is, how does a judge or a jury actually draw the line?
Exactly. And to answer that, we have to shift our focus from the settlement itself over to the Supreme Court.
Yeah.
Specifically, a landmark case known as FTC v. Actavis.
Right. So prior to the Actavis decision, courts were deeply divided on how to handle these reverse payments.
It was basically chaos, right?
It's complete chaos. Some courts argued these payments should be per se illegal, meaning the moment you pay a competitor to delay entry, boom, you've broken antitrust law.
And what was the other side arguing?
Others argued for near total immunity. They basically said that as long as the generic's entry date falls somewhere within the lifespan of the brand's patent, it's just a perfectly legal use of the patent monopoly.
So the Supreme Court took up Actavis to settle this division, and they rejected both of those extremes, didn't they?
They did. They didn't want to ban settlements outright because, settlements generally benefit the judicial system. They clear up the dockets.
Sure. But they also couldn't just allow companies to buy their way out of competition.
Right. So they created a middle ground, establishing what's called a rule of reason framework.
Okay, rule of reason. What does that actually mean in practice?
The court decided that the actual size of the reverse payment should serve as a proxy for the weakness of the underlying patent.
A proxy. Okay, so the logic kind of makes intuitive sense. A pharmaceutical company is not going to hand over $210 million to a generic competitor if they are absolutely certain their patent is bulletproof.
Exactly. They only pay massive sums if they are secretly terrified of going to trial and losing their monopoly entirely.
So by looking at the size of the payment, the Supreme Court thought they were giving lower courts a convenient shortcut.
The intention was highly pragmatic, honestly. The Supreme Court wanted to spare antitrust juries from having to conduct what we call mini trials. Yeah. Antitrust trials are already incredibly dense. They deal with market definitions, economic overcharges.
That's a lot of math.
Tons of math. Forcing a jury of laypeople to also learn the highly technical chemistry of a pharmaceutical patent just to determine if it would have held up in a hypothetical alternate universe. It's a logistical nightmare.
Right, so the court instructed lower courts just skip the chemistry and look at the economics. The money tells the story of the patent's strengths.
That was the idea, yes.
But this shortcut introduces the fatal logical flaw that the EconWorks article highlights. The math is completely circular.
It is entirely circular.
Here's where it gets really interesting. To decide if a $210 million payment is an, quote, unexplained massive overpayment, you have to compare it to the expected value of the patent.
Let's actually map out the source's numerical example to see how this breaks down in practice, because it's fascinating.
Okay, let's do it. Suppose a patent protects $100 million in future monopoly profits.
Right. Now, if you go to trial and the generic has a 25% chance of winning and breaking the patent,
then the expected value of your patent is $75 million, and the expected value for the generic is $25 million.
Exactly. But if the generic has a 50% chance of winning, their expected value is $50 million.
Right. And you need to know that expected value to evaluate the settlement.
Yes. Because if the generic's expected value from a trial is only $25 million, and you hand them $210 million to go away, well, that is obviously an excessive anti-competitive payoff.
But wait. The entire Actavis framework relies on using the payment size to guess how strong the patent is.
Yep.
So to know if the payment is large or excessive in the first place, you already need to know how strong the patent is so you can calculate the expected value.
You're hitting the nail on the head. The rule requires its own conclusion as an input.
It's completely circular. It's the equivalent of telling someone to guess a person's height by looking at their shoe size, but then you provide a formula that calculates their shoe size by measuring their height.
That's a great analogy. This is what the article calls the Actavis circularity loop.
The Actavis circularity loop. So the framework replaced a binary legal standard, meaning a patent is either valid or invalid, with a probabilistic standard.
Right. It asks courts to operate based on the probability of the generic winning a trial that never even happened.
Yet it provides absolutely no legal, scientific, or economic mechanism to actually generate that probability.
None at all. The Supreme Court essentially mandated a math problem that cannot be solved without just making up a variable.
Wow.
In the real world, there is no universally accepted empirical method in law or economics for generating the objective probability of a patent's strength out of thin air.
You can't just plug a patent into an algorithm and get a clean percentage chance of success.
No, you can't. The Actavis test doesn't eliminate the need to answer the complicated patent question. It just embeds the patent question implicitly into a completely broken equation.
Okay, so if the math is functionally impossible, we have to look at how the jury in Massachusetts managed to actually award $885 million.
Right, because they couldn't just leave the verdict form blank. They had to navigate the circularity loop in real time.
Which requires us to examine how damages are actually calculated in antitrust cases. Specifically, this concept called overcharge damages.
Overcharge damages. So, when a generic is kept off the market illegally, consumers and insurance companies are overcharged because they are forced to keep buying the really expensive brand name version.
And to calculate those overcharge damages, the plaintiffs have to construct a hypothetical alternate reality.
Yes, they must provide the jury with a but-for entry date.
A but-for entry date, meaning this is the exact date the generic would have entered the market if there had never been a reverse payment settlement.
Exactly. But in the Takeda trial, the plaintiffs didn't provide a single definitive date. They offered the jury a menu of hypothetical scenarios.
A menu, like multiple choice.
Pretty much. They suggested maybe the generic might have entered in 2016, alternatively maybe April 2018, or perhaps 2020.
And the jury ultimately selected April 2018.
They did.
But wait, by selecting that specific date, the jury was implicitly making a massive judgment about the strength of Takeda's patents.
Absolutely. Picking an earlier date means they believed the patent was weak and would have been invalidated quickly in court.
But they made this determination without a mini-trial, without a probabilistic formula, and without adjudicating the actual chemistry of the patent.
Right. They bypassed the missing variable in the Actavis loop by simply choosing a narrative they found compelling.
They just pick a story they liked.
If we connect this to the bigger picture, the mechanics of how they attached a dollar figure to that April 2018 date reveals the true depths of the disconnect here.
Okay, how did they get the dollar figure?
Economic experts calculate antitrust damages using something called the yardstick method.
The yardstick method.
Think of it like trying to assess the financial damage of a house fire. You don't have a time machine to see what your specific house would be worth today. Instead, you look at a comparable house on the same street that didn't burn down. That's your yardstick. You map its value over time and apply that trajectory to your own property.
So in this context, an economist looks at a comparable drug in a similar market that actually did experience normal generic competition.
Exactly. They measure exactly how fast the price dropped when the generic launched, and they apply that percentage drop to Emetiza's sales data.
I see. So the yardstick method does the vertical math brilliantly. It tells you how steep the price drop should be.
Yes.
But it does absolutely nothing to establish the horizontal starting point. It cannot tell you what day the price drop is supposed to begin.
Bingo. The yardstick method is a highly rigorous, well-established tool in economics. It is peer-reviewed, it's mathematically sound, but it only answers a conditional question. Given an entry date, what is the financial overcharge?
So the yardstick method is doing highly sophisticated, rigorous math, but it's completely reliant on a date the jury basically just picked from a multiple choice list.
Yes. The rigorous math is entirely dependent on the entry date plugged into the model. Since the legal framework provided no objective way to calculate that date, the jury's decision was an exercise in narrative selection.
Aren't they just selecting a story rather than applying economics?
That's the core revelation of the Takeda case. They listened to competing stories from lawyers and picked a date that just felt right. The trial shifted antitrust enforcement away from structured economic inference and turned it into a creative writing exercise.
A $2.5 billion penalty built on narrative guesswork is surely not going to stand unchallenged.
Oh, absolutely not. Takeda is appealing the verdict to the First Circuit Court of Appeals as we speak.
And the stakes here go far beyond Amitiza or even Takeda as a company. This appeal is going to put the entire Actavis circularity problem under a massive microscope.
Takeda's legal strategy is likely going to attack the fundamental mechanics of exactly how that April 2018 date was chosen.
What's their primary angle?
Well, one of the main targets will be the jury instructions. The trial judge likely instructed the jury following the Actavis mandate, telling them they did not need to formally assess the validity of Takeda's patents to reach a verdict.
Right, the whole point was to avoid the mini-trial.
Yet, the damages model required the jury to select an entry date, which is implicitly an assessment of patent strength.
So the instructions are internally inconsistent.
Exactly. Takeda will argue those instructions are fatally inconsistent. You cannot tell a jury to ignore the patent's strength while simultaneously demanding they pick a date that is entirely dictated by the patent's strength.
That makes total sense. And if the date is essentially just pulled from a list of hypothetical scenarios, I have to imagine Takeda will also target the expert witnesses who presented those scenarios to the jury.
Yes, this brings the Daubert standard into play.
The Daubert standard.
Yeah.
That's the rule for expert witnesses, right?
Right. In the federal legal system, the Daubert standard is the gatekeeper for expert testimony. A judge is supposed to block junk science from reaching the jury by ensuring an expert's testimony is based on a testable, peer-reviewed methodology.
So how does that apply here?
The Daubert challenge is arguably the most critical piece of the appeal. Takeda will point out that the economic experts for the plaintiffs did not use a scientific or mathematical formula to generate the April 2018 date.
Because there isn't one.
Exactly. If an expert simply offers a jury a multiple-choice menu of hypothetical entry dates without an underlying equation to derive those dates, Takeda will argue that is not a methodology at all.
So under the Daubert standard, presenting speculative counterfactuals without empirical backing should have been inadmissible from the start.
That's the argument. Scenario selection is not a methodology.
So what does this all mean? If the First Circuit agrees with Takeda and says you must have a mathematical method to pick a date, but we already established no such method exists, doesn't that mean the entire Actavis framework is fundamentally broken?
That is the gravity of the situation. The EconWorks article refers to this as systematic indeterminacy. We are left with a system that simply cannot function as designed.
Systematic indeterminacy. That sounds terrifying for the market.
The implications are profound for the healthcare market. Pharmaceutical companies rely on massive long-term investments to develop new drugs. They require a degree of regulatory predictability.
Right.
If the legal system cannot reliably distinguish between a pro-consumer settlement that efficiently resolves a dispute and an anti-competitive delay that harms the public, then every single settlement a pharmaceutical company signs becomes a multi-billion-dollar roll of the dice.
Which is crazy.
From both a legal and an economic standpoint, treating billion-dollar industry practices like a lottery is incredibly difficult to defend.
Okay, let's trace the path of this entire deep dive to really cement this. We started with a localized dispute over a single medication, Amitiza.
Right, looking at a $210 million deal wrapped in profit sharing and authorized generics.
And attempting to judge the legality of that deal pulled us into a circular Supreme Court logic puzzle.
The Actavis circularity loop.
The Supreme Court's attempt to simplify the law by avoiding patent trials accidentally replaced a resolved legal question with a completely unresolved economic one.
And that missing economic variable dumped us straight into a $2.5 billion jury verdict that rested entirely on a jury picking a hypothetical date out of a hat.
The Takeda case really is a masterclass in unintended consequences. A legal framework designed to protect consumers from anti-competitive behavior has mutated into a system where damages are decoupled from objective reality.
And until an appellate court like the First Circuit directly confronts this circularity and demands a measurable standard, reverse payment litigation will continue to operate in this massive gray area.
So if the legal system currently relies on juries playing the role of pseudo-economists, guessing how a patent trial would have gone in a parallel universe, what's the alternative?
That's the million or billion-dollar question.
Right. Are we waiting for Congress to rewrite the Hatch-Waxman Act? Or could we eventually see the use of AI modeling or specialized prediction markets to objectively score a patent strength before these pharmaceutical companies are even allowed to sign a settlement?
That would be a game changer.
Imagine an algorithm objectively defining the probability of generic success, giving courts the missing mathematical variable they desperately need. But until we find a real measuring stick to replace the broken Actavis loop, the multi-billion-dollar question remains entirely unanswered.
It really does.
I want to leave you with that to ponder.
Okay.
Keep questioning the unseen systems around you, especially when the highest courts in the land hand you a locked safe and just ask you to guess
Thanks
the
for
combination.
tuning into this episode of
joining us on this deep
Econ
dive.
Works. The goal of this series is to move beyond the surface-level descriptions of how markets work and start looking at the actual architecture of competition. We'll be back soon with another look at where the law and economics meet the market. For the full technical analysis and more from this series, visit us at econworks.com. If you found today's breakdown valuable, please subscribe and share the show. It helps us keep the analysis independent. From all of us here at Econ Works, thanks for listening.